Good afternoon, everyone. My name is Rick Weber. I am a litigation attorney here at Schoeneck King, and it's my pleasure to welcome you to the second episode of Bond's three-part review of how a pandemic impacts your contracts. Episode 1 was last week, and that included a quick rundown of key contract terms that are important now more than ever in the face of the COVID-19 crisis, and gave some guidance on what you should be reviewing your contracts for as you try to work through some of the challenges your business may be facing. Next week will be episode 3, and in that episode we're going to drill down a little more deeply on some litigation remedies and some actions you may need to be considering in regards to contract performance or non-performance issues. Today's episode is focused on a little bit of specifics on certain subject matter areas in regards to contracts. So we're talking about some leases, for example. We're also focused a little bit today on what might happen if you have fears that a party in contract with your business may be facing some insolvency challenges. We wanted to get some thoughts out about that. So we have a fantastic panel lined up today. John Elliman is going to be up first. John is based in our Syracuse office. His practice includes a broad range of commercial real estate areas and transactions. He spends a substantial portion of his time on financing transactions as counsel to developers and lenders. He is an expert in the area of business leasing and general commercial transactions. Our second presenter will be Joe Kubarik. Joe is based in our Buffalo office, and his practice is concentrated on mergers and acquisitions, as well as securities, corporate finance, and corporate governance matters. He represents clients engaged in a broad range of business activities, ranging from aerospace and real estate development to insurance and financial services. And finally, Sarah Temis, one of our business restructuring, creditors' rights, and bankruptcy attorneys, who is based in our Syracuse office, will give a presentation on some issues related to insolvency matters. She concentrates her practice on a wide range of business restructuring and bankruptcy matters, including out-of-court workouts, cross-border insolvency cases, and representation of debtors, creditors, landlords, lenders, and purchasers in cases filed under Chapter 11 of the U.S. Bankruptcy Code. So with that, I'm going to turn it over first to John Elliman, our first speaker today.
Thank you, Rick. Folks, today I'm going to talk a little bit about the specific type of contract, leases, because there are so many businesses that do lease properties. Oftentimes, the lease expense may be the second largest expense that a business has, in addition to its personnel and overhead. So many businesses are faced with the idea that they are facing monthly rent without income. And so it's a very universal issue that's plaguing both the tenants and the landlords. We get numerous requests on a daily basis for some assistance in that area. And hopefully today what I can do is give you some thoughts about what we think might be a good way to handle the process. And certainly we're available to assist you with any specifics you might have. So with that, really the first item, as you might expect, is to take out the lease from the drawer. Hopefully it's dusty and hasn't been looked at, because you do have a great relationship with your landlord. Some people do, some people don't, but in any event, we need to take a look at the lease. We're going to focus in on certain things, not to get people's hopes up. A lot of times the lease examination process is not going to result in a magic provision that allows you not to pay the rent. However, there are aspects to the lease that are important for analysis. And so we would look at those things. Sometimes you may have heard people talk about things like acts of God. We usually refer to it as force majeure. We'll look at those provisions. Now, most often they'll have a little provision that says doesn't apply to payment of rent. You still have to pay the rent. But there are varying degrees of sophistication among a lot of different leases. There are also some other aspects of lease provisions which might give rise for us to consider whether impossibility of performance might be a way to get some relief from the process, frustration of purpose. There are several of those, and I think probably some of those will be covered in more detail when as Rick mentioned, next week we have a part 3. And it's going to be more than just leases. It'll be all types of contracts. And there are certainly legal positions out there that are defendable, have been recognized by courts, that do give certain relief. But with that said, the purpose of today's discussion really isn't going to be that we're going to examine all of our legal defenses involved. What we've tended to do now is try to focus on some solutions. And part of the solutions have to do with what, if anything, is the government offering. Now, we practice in multiple states and we have clients all over the place. But in most cases, because we have the most offices in New York, you may find that people are more familiar with New York. And what I'm going to tell you often will apply in certain jurisdictions and not others. We certainly can help you out if you live in any of the states. If you have specific questions about what relief, if any, the government's had. Because we do have a large number of New York clients, we have had many questions asked about a couple of things the state has done to help relieve certain businesses and what they do and what they don't do. So often people have said, hey, do I have a right not to pay my rent? Because I heard that the landlords, they don't have to pay their mortgages anymore. Well, there is a mortgage relief in New York. I think there's one in Florida as well. I know out in California there's one, and I imagine there's probably similar in many states. However, in New York, and I would assume the same as in other certain states, is it's only going to affect those lenders that landlords have that are regulated by the state. Many lenders are nationally regulated. There are reasons that they do that. And the federal government under the CARES Act did not implement any relief from commercial landlords to not pay mortgages. And as a result of that, you can't assume that your landlord is going to be free from the payment of their loan and therefore is going to be quite receptive to you not paying rent. The second thing that can be confusing, and this is something that other jurisdictions have done as well, including Florida, is they have put a hold on instituting and proceeding with eviction proceedings. Again, this is an area that often gets confusing for tenants. Is, does that mean I don't have to worry if I don't pay my rent? Not necessarily. If you are simply going to act unilaterally, not pay your rent, there's an entire possibility that you will be held in default by your landlord. And if the landlord has a right under the lease after a default and cure period is run to terminate your lease, you could find out that you are unable to pay after the fact and reinstate the lease. Florida, for instance, does give the courts the right to reinstate a lease. New York doesn't. If it's been lawfully terminated by the landlord, you'd be out of luck. So obviously, knowing what the government does and doesn't provide is an important step to analyzing it. So we want to mention it here. The other thing is the Paycheck Protection Program, the PPP loans. People are unaware of the fact that 25%, up to 25% of that loan, if you are a tenant, can be used to pay rent. That can be important because it can be something that people are assuming you can't use for those purposes. After all, the idea is to somehow keep the business going in a way that you can support as many employees as you can. Certainly wouldn't at first think it's okay under the program, but in fact it is. There has been some bad press on the PPP loans lately. Some people have heard about things like the Celtics and Harvard. And the government has come forth and said there will be some scrutiny on this, but I don't think people should shy away from the loan at this point. We do have information, other presenters, not in this particular program, but we have done some in the past, and they are available on our site, which will allow you to actually understand what's necessary, determine whether you qualify, and if you do, it may be the right thing for you. So now what we really are focusing on is what are we going to do for solutions? And one of the first things that we're going to ask you is, what is your relationship with your landlord? Are you in a position where you'd feel comfortable instituting a discussion with them? You have to keep in mind, landlords often are very receptive. We're all in the same boat, and are willing to, in fact, do some discussions. I don't have a lot of time left, but let me leave you with a few thoughts that you may incur if we are involved in the process of resolving it. Typically, you're going to want to make sure that you have a non-disclosure agreement with your landlord, and most landlords want the same. You don't want your financial information to be available to others, and often you are going to be called upon to provide financial information. The other thing that you have to consider is with certain businesses, closely held businesses, some landlords have asked for personal guarantees when they haven't had those necessarily with the lease. Sometimes we've been asked to see other assets and whether or not they can securitize them. So what you're going to run into with your landlord is all over the place. Some of them are very good about allowing delays. Some of them will let you pay it over time, but some of them say, we can't. We have to keep our cash flow up or we're going to default on our mortgage. And as I mentioned to you, not all landlords are really going to be relieved from mortgage payments. So that is some of the things that are happening. The other aspect to the negotiation, which you should keep in mind, and we need to be aware of it, is, March is coming up at the end of this week. Payments are usually due in March. Some people say, I can't pay. And you might not be able to pay in May, but you also may not be able to pay in June, July, and August. You have to look ahead, and we're encouraging people because businesses aren't going to open up like a light switch. Everybody's going to be back to full force. Everybody's going to be back to full income. And so when you do this discussion, we would encourage you to look at it at a little longer period of time, because over time, there will be less and less desire for the landlords to offer flexibility, nor may they not have the opportunity. So now's the time to think ahead and try to plan for that. And don't be shy about asking your landlord essentially to be your bank. Some landlords are asking for interest on late payments of the rent. Others aren't, but even the ones that are doing it at a rate that still may be much better than trying to get money from a bank. All in all, if you have any discussions or questions about resolving these matters, give us a ring. We can help you. We've been doing it day in and day out for the last few weeks. Back to you, Rick.
Great. Thank you, John. Thank you, John. Next, we're going to shift to Joe Kubarik. So, Joe, you have the floor.
Thanks, Rick. As Rick said, I'm Joe Kubarik. I'm a partner in our Buffalo office. I'm going to spend a few minutes talking about the typical provisions of a property insurance policy that relate to business interruption and the prospects of recovery under such a policy for shutdowns related to the coronavirus. Business interruption insurance, also known as BI insurance, and expands to the first slide, would you please, Kathy, is provided as a part of first-party property insurance usually. The policy obligates the insurance company to pay benefits directly to the insured in the event of a covered peril. BI insurance may compensate for certain losses related to the slowdown or suspension of operations. The recoveries can include lost revenue, certain expenses, including rent, relocation costs, employee wages, taxes, and loan payments. The goal of BI insurance is to replace lost profits as a result of the suspension or slowdown of operations. A typical BI insurance policy written on the Insurance Services Office form requires that the loss for which an insured is seeking recovery be caused by direct physical loss to property. As I said at the beginning, this is property insurance. So the coverage is dependent on a physical loss to property. The precise language in a typical BI policy form requires direct physical loss, damage, or destruction to property. And the loss or damage must be caused by a result of the covered peril. As a result of this language, insurers are uniformly denying these claims, taking the position that the presence of coronavirus does not constitute a direct physical loss or damage to property, and the coronavirus-related shutdowns to prevent the spread of the virus are not physical damage to property. There have been, and there will continue to be lawsuits challenging these denials, which I'll talk about in a few minutes. Next slide, please, Kathy. The typical business interruption insurance policy also contains exclusions from coverage that may make recovery under the policies problematic or impossible, even assuming it can get past the actual physical damage question. These exclusions include pathogen exclusions, which were written in by ISO in response to the SARS epidemic in 2003, which exclude loss or damage caused by or resulting from any virus, bacteria, or other microorganism. They also universally have pollution exclusions, which don't include a specific direction, the definition of pollutant, giving the insurance companies the opportunity to argue that coronavirus is a pollutant and therefore coverage does not obtain. The next slide, please. A business should take a very careful look at its insurance policies to determine whether there are any coverage that may be related for available for coronavirus-related losses that does not a traditional business interruption policy. For example, many policies contain endorsements that provide for civil authority coverage. This endorsement insures against losses resulting from governmental or military orders that prohibit access to an insured premises. Again, depending on the policy language, this coverage is often dependent on there being actual physical damage to the insured's property, or in some cases, a property near the insured's place of business. I have seen a couple of civil authority endorsements, however, that allow the insured to collect from the insurer irrespective of physical damage. Unfortunately, from the point of view of the insured, this coverage is usually subject to much lower policy limits than the more general business insurance company, business interruption insurance would be subject to. Just as an example, I saw a client that had a BI limit of several $1 million and who had civil authority coverage, and the limit for the civil authority coverage was $50,000 per occurrence, with a total of $100,000 over the term of the policy. You may have procured other unique coverages that relate to your business that you should carefully examine. An event cancellation policy, for example. Each business should carefully examine this coverage with its insurance professionals. The next slide, please. As I noted earlier, there have been and continue to be a multitude of lawsuits challenging the denial of these business interruption insurance claims. There's some case law to support the argument that coronavirus is a direct physical loss. And one New Jersey case unrelated to coronavirus, the court held that the presence of ammonia in an insured's facility was sufficient physical damage to invoke business interruption coverage, even though there was no structural or similar damage to the insured's facility. There are a few other similar cases. Plaintiffs are using these and similar theories to attempt to convince courts that the possible presence of coronavirus is physical damage that implicates business interruption coverage. Another argument that's being made is that the governmental shutdown orders themselves, in and of themselves, are physical damage to property. Still other cases are attempting to appeal to the equitable grounds, arguing that the insureds paid premiums for business interruption coverage, specifically to protect against situations like coronavirus. Many of them purport to be class actions, like one that was filed just yesterday. I saw it on the internet this morning in Buffalo against Hartford Insurance and several of its affiliates. These litigation matters are going to be played out over a period of many years, and unfortunately will be a little used to a business that's struggling right now to survive. There are also some legislative proposals to attempt to rewrite the existing business interruption insurance policies to force BI claims to be covered, BI claims related to coronavirus to be covered. It's been proposed in New Jersey, Pennsylvania, Louisiana, New York, Ohio, and maybe a few other states. The legislative proposals usually focus on providing business interruption insurance to small businesses with respect to policies that were in effect when the particular state declared a state of emergency. Some of them are quid pro quo proposals, which would permit insurers to seek reimbursement from the state for the claims that they pay out, and the states would then surcharge back on all insurers selling policies in their jurisdiction to recoup the reimbursement payments. There's also proposed legislation in the House that would retroactively mandate business interruption coverage and invalidate pathogen exceptions. And the House proposal would apply to a business irrespective of its size. The insurance industry obviously is not happy about these bills, and they've raised various issues, including that the legislation attempts to overturn several centuries of contract law precedent. The state versions of the legislation that apply only to small businesses discriminate amongst claimants. The proposed legislation violates the Contracts Clause of the Constitution, which provides that no state shall pass any law impairing the obligation of contracts, and an insurance policy is a contract, and that it may result in the insolvency of many insurers. With respect to the insolvency issue, the National Association of Insurance Commissioners, which is the overseeing group for all 50 states' insurance regulatory agencies, has urged Congress not to take any action that would require insurers to cover coronavirus losses, arguing that the customary business interruption policy was not designed or priced to cover communicable diseases and to forcing coverage would cause insolvency. For all these reasons, many lawmakers and industry observers that believe that the federal government solution, similar to TRIA, which is after the terrorism risk after the September 11th attacks, is required. In the meantime, I'm urging all of our clients to carefully review their insurance policies and consult with their insurance professionals and attorneys to determine whether there is any coverage arguably implicated, and to file appropriate claims as quickly as possible. And with that, Rick, I'll turn it back to you.
Great. Thank you very much, Joe. I'm going to turn the presentation over to Sarah here. Just real quickly, I want to apologize. It looks like we had a short hiccup and we lost the slides for a couple seconds, but we got them back. Also, if you have any questions, by all means, send us your questions using the question and answer function in this program. And we'll see if we can get to them, if not during Sarah's presentation, at the end of Sarah's remarks. So take it away, Sarah.
Am I unmuted? Okay, thanks. Hi, good afternoon. As Rick said, I'm a member of our firm's business restructuring practice group, and we also do bankruptcy law, in-court, out-of-court restructurings, and creditors' rights, general matters. Today I'll address a few basic business bankruptcy and restructuring issues, but mostly aimed at when you find yourself dealing with a business that's in trouble, not necessarily looking at this from the perspective of my business is in trouble, but when you find yourself dealing with a distressed business, which could be either your customer, a contract counterparty, or another business partner, that situation may become more and more common in your business over the past few months. And it looks like as the economy restarts, there are going to be many businesses that have been starved of revenue stream, and they'll be considered distressed. How will you know that you're dealing with a business that's in a distressed situation? Sometimes they'll come right out and tell you. They may ask for payment terms. Other times they'll just become slow pay customers or fail to pay their outstanding invoices at all. In order to take a closer look here, we're going to need to look at a few different types of business transactions, and that's the first slide here. Three major types of business transactions are the most common: a business credit transaction, which is delivery prior to payment. Then you have a situation where you're dealing with maybe payment prior to delivery, prepayment, or payment at the same time as you deliver your goods, a cash and carry or a cash on delivery type of transaction. And those will become important in a few minutes when we talk about protecting yourself when you're dealing with an entity that may enter a bankruptcy, a Chapter 11 or other proceeding. So you need to change your business strategy oftentimes when you're dealing with a distressed company. You should try to avoid credit transactions if at all possible, or consider getting a security interest or entering into a consignment arrangement if you're dealing with a customer that you're potentially delivering goods to, that those goods may be incorporated into final products. You need to get close to their financial information, and in particular, you want to probably consider your exposure to preferential transfer action, and I'll get to that again in a minute. So next slide, please. At the first hint of trouble, there are a few things you can do before any bankruptcy case is filed. You want to assess whether or not you have a contract with this entity. And if you sense danger potentially because you have somebody who's asking you for different payment terms or otherwise, you might want to consider terminating the contract or modifying the contract terms, because you can't do that once they enter a bankruptcy proceeding. You may want to look at that contract really carefully to see if you have termination rights, or if there's a default that you can call to consider whether or not a termination is appropriate. Because once you get into a bankruptcy case, you're required to comply with the terms of that contract for the most part. The debtor can pay you and will pay you and should pay you going forward, but you're sort of stuck with what you have once a bankruptcy case is commenced. You can't terminate the contract unilaterally at that point. And then you want to look at the risks that you have under the current contract if you have to keep performing, and just assess those and understand that that's what you're getting into. It's good to get paid on a general ongoing basis from that customer, but you want to be aware that some of those payments may be clawed back as preferential transfers. So I often find that it's helpful for when I'm counseling clients in these situations, it's helpful for people to understand the policy behind the preferential transfer, the 547 of the Bankruptcy Code. If you receive a payment, oftentimes people come to me and say, my customer filed bankruptcy. I've got two problems. They owed me a lot of money, number one, and then the trustee is trying to get the money that they did pay me back. So that's a real problem, and it's a really hard thing for business owners to get their arms around. Why is this happening? The policy behind preference law is sort of twofold. One is you don't want people to be racing to the courthouse or sort of just trying to dismember a troubled company right before it files a bankruptcy case. You don't want people you don't want to encourage people running in and trying to grab as much as they can. And then secondly, and I think more importantly, within the bankruptcy case, the trustee will try to marshal all the potential assets that would be incorporated into the bankruptcy estate and have those distributed evenly amongst all the creditors. So you would give the money back, and then that would be part of the pool that everyone would be sharing at that point. So understanding those policy concerns, it helps you a little bit to understand some of the defenses. So if you have a customer that you've determined is in trouble in some way, you want to keep your transactions with them rather ordinary. So you want to be able to be entitled to that ordinary course of business defense, if at all possible. And these are for transactions within the 90 days prior to a bankruptcy filing. So if you've kept your relationship with that customer pretty ordinary, then keep going along the same terms. And prepayment or COD pretty much takes you completely out of the preferential transfer world. So that's not a preferential transfer if you've got payment on delivery or prepayment. So if you can change to those types of transactions, it's all the better. So if you try to change your credit limit or change your payment terms or do something to reduce your risk at that early stage. Next slide, please. So when a company is jumps into a Chapter 11 or files their petition, how will you get paid? So if you're continuing, you can continue to ship on credit once they're in a bankruptcy case. And post-petition claims have to be paid in the ordinary course of business, and they must be paid before everyone else. So you might want to look at the bankruptcy case and consider whether or not it's viable. You can look at the budgets because everything becomes public. It's all publicly filed, and monthly operating reports are there. So you can have your attorney look at that, or you can even pull it up from the court's website yourself, or give us a call, and we're happy to walk you through it. If it's a particularly large transaction or outside the ordinary course of business that you're dealing with, something that you want to do with this contract counterparty, like a huge order, you may want to get court approval first, because that entity is not going to be entitled to just do business as usual. If it's a big transaction, you're going to need court approval, especially if you're going to buy a division of that business or something else. If you're doing anything other than a normal business transaction that you did before the case, then you're going to want to get court approval. So you want to reach out to an attorney. And then, do you have a contract? You have to keep performing under that contract, as I mentioned before. So I know we're running out of time a little bit. So next slide. All right, so you're going to want to file a proof of claim in that case. And then you may want to look at whether or not there's critical vendor status. You may be able to be paid a portion, all or a portion of your pre-bankruptcy claim if you provide a unique good or service that the debtor can't get elsewhere. So that's something to consider and ask about at that stage. And then there's certain priority claims that you might get for pre-petition goods that you shipped within the 20 days before a bankruptcy filing. This is linked up a little bit to to reclamation claims, and linked up to reclamation claims and UCC general claims for being able to take back goods that you've given to an insolvent entity. So that's something to look at. And I know we're running out of time, so next slide quickly. Oh, one more. Sorry. All right, and then bankruptcy outcomes generally. So oftentimes these 11 cases will end in a 363 sale or a sale of assets or a plan of reorganization. The sale is usually an open process subject to higher and better offers. If it's a business that you generally work with, that you potentially it's a competitor or an entity that you may you may want to consolidate with your business in some way, keep an eye on the case and see whether or not there may be a reason to go in and figure out whether or not you should make a bid for the assets. So sales in bankruptcy are free and clear of liens, claims, and encumbrances, and you're going to want to look at the papers really closely. A plan of reorganization will lay out the treatment of all claims and the debtor's ability to comply with its obligations post-bankruptcy. It'll have to show its feasibility of a plan going forward. It may also address the issues of assumption and rejection of contracts, and that goes back to assessing your contractual relationship with this potentially distressed company at the very early stages. So that's a really quick synopsis of a lot of different issues, and I'm done as that. Thanks, Rick.
Sarah, thank you. I want to thank all our presenters at this time. We had one question that had come in the queue, and it's a question about whether we're going to make the slides available on the PowerPoint. The slides and, in fact, a recording of this presentation are going to be available on our website by noon tomorrow. So certainly you'll be able to get access to them through that method. If you'd like to get access separately too, you can certainly contact us or your standard bond attorney. So I want to thank everyone for attending. On behalf of all our presenters, Joe, Sarah, and John, we certainly want to wish you and your business the best during this difficult time. Hope you're making it through this challenge, and hopefully we're coming towards the next stage here where we can start getting everybody back to work and getting the economy moving again. Please feel free to contact us, any of these presenters, or contact your regular bond attorney if you have any questions or any other thoughts. With that, again, I want to thank our presenters. I want to thank all of you for attending. Everybody stay well. Thank you.
Thanks.